Simmons from the OPC, Ms. Judith Grant and Ms. Crystal Paris Campbell. From the Ministry of Justice, Mr. Paul Bailey and Ms. Chantal Bailey, right. And also from the Attorney General's Chambers, Ms. Masado and Ms. Adams. And we welcome the Children's Advocate. Nice to see you, Mrs. Gordon Harrison. And members, welcome to the meeting this afternoon. We also have with us, as soon as two members from the Correctional Services, Dr. Mark Thomas, who is the Commissioner of Corrections, and also Ms. Claudette Hamilton. And I suspect you're with the Juvenile Center. We're going to take you soon, okay? So we can release you. But the truth is that Senator Shireen Campbell-Golden begged us to delay your presentation so she can be better informed, okay? She said she's on her way and she's trying to get here as quickly as possible. So in the meantime, what we're going to do is to take the minutes. Remember, we had indicated we'd take the minutes. So please, members, we have 5 minutes. We have 5 minutes for whichever. So I'm going to depend on you to, if there are any corrections, you can make note of them as I call, field in which I'm going to ask for approval. So the first one is June the 20th, 2023. Are there any corrections? If there are no corrections, I beg for motion for adoption. Sorry? You have one, you say, June the 20th. Anyone has any corrections? That's June the 20th. Minister Williams, you said you had one? Well, later on, if you find the corrections, you can you have a motion then? So moved by Senator Gale, Kevin Gale, and seconded by Minister Williams. The next one is July the 18th, 2023. We welcome the SG. When we were welcoming, you were out of the chambers, but we welcome you, SG. The 18th, if there are no amendments, can we have a motion for adoption? Yes, yes. No, okay. Yeah. Oh, no. It's wrong. Right. That's correct. That's correct. So 2003 is 2023. Here. Fourth line to 2023. All right. If there are no other corrections, motion moved by Senator Charles Sinclair, seconded by Senator Gale. Or should I say Senator Scott Motley? Right. The next one is the 26th of July. Are there any corrections? Okay. 26th of July. So moved by Senator Sinclair, seconded by Senator Binns. Then the next one is the 19th of September. Is that the one? 19th of September. Is that the one that had the correction? On page 8, I saw a correction there. Say about page 8 to the 19th, about the 7th line, where it said, he noted that victims and their families would want to see offenders being treated, not being treated. So we have to take out the not. Being treated in a manner commensurate to what they have done. So remove the not, please. Any other corrections for September the 19th? If there are no other corrections, I have a motion for adoption. Senator Gale, seconded by Senator Motley. And the last one is September the 26th, so 27th. Is that right? Yes. There are some minor corrections, but I've noted it to the secretary. Where, for instance, on page 6, the third paragraph, about the 8th line, it should say, feel that justice was served instead of serve. And on page 7, about the 10th line, it says, explain that the likelihood was the number of years to be determined instead of determined. If there are no other corrections, we can have a motion for its adoption. Senator, motion moved by Senator Gale, adopted by Senator Motley. All right, thanks very much. Any matters arising that anyone would raise from any of the minutes, failing which we may have 2 more minutes, the one from yesterday and today, but there wouldn't be ready, obviously. I want to welcome Senator Shireen Campbell-Golden, who is now here. Now, members had asked yesterday for input from the correctional services in relation to programs that could be offered to assist children when they're convicted for a crime, but in particular, murder. The correctional services, quite nice. Could you get that to Senator? You got one, too? All right. Provided us with a list of offerings of programs that they put on to assist children in rehabilitation. Okay? But before, what I'm going to do, Dr. Thomas and Ms. Hamilton, we'd ask you to just give us a synopsis of the type of children you deal with, the numbers, and the offenses for which you have them. You can speak now, Dr. Thomas.
Good afternoon, everybody. The presentation or the response will be from our Director of Juvenile Services, Ms. Claudette Hamilton. She has been with this committee for a while now, so I'll hand over to her.
Okay. All right. Speaking, okay. The information he said is Dr. Thomas, who is the Commissioner of Corrections. He has passed the burden on to Ms. Claudette Hamilton. And Ms. Hamilton, you could tell us your position and which institution or generally your position in the correctional services.
Thank you, Chair. Members, good afternoon. My colleagues. I am Claudette Hamilton. I'm the Director of Juvenile Services. which means that I would oversee the operations as it relates to both their academics and other psychosocial needs. So currently we have 4 juvenile institutions. Up to 2021, there was one, Hilltop, at Bamboo in St. Ann. It is currently at the location of the Rehoboth Juvenile Correctional Center, which is in Tredegar Park, St. Catherine. So we have 3 institutions that house boys. The Metcalf Street Remand Center, which is the only remand facility, and that is where we have the bigger population. Currently, we have 83 wards there. We have
just 83 wards at Metcalf.
right today, and that number fluctuates on a daily basis. At South Camp Juvenile, this is the only female institution. We currently have 75 girls, 46 on remand, and 29 on correctional order. At the Rio Cobre location, we have 46 wards, and that includes 19 of them who are of a high security nature, those that would have been sent to the Hilltop location. So the profile of these children coming to us, the offenses range from simple larceny to murder. What we have found is that the majority of offenses are more of an heinous nature. Metcalf Street population of 83 would have only 3 uncontrollable today. And that means that the majority of offenses are ranging from possession to assault, OB, rape. The Rio Cobre Juvenile Institution now is a medium security institution, and that would house the children of a lower crime offenses, like simple larceny and breaking, shop breaking, house breaking. For South Camp Juvenile, the majority of the girls there are for uncontrollable. And so for the remand population, which stands at 43, you would find that 3/4 of those girls are there for being uncontrollable. The others would range from murder, simple larceny, and assault, OB, arm.
Just Hilltop. What happened to Hilltop?
The Hilltop population would be those that would come from court, and the judge will say on the order they have to go to Hilltop, or sometimes those that would be there and awaiting their transition to adult institutions.
Okay. Just when you're ready, members, I'll allow you, but just a minute. No. Press again.
I'm sorry. No, I was just asking if you could just repeat the answer you gave to the chairman a while ago.
The Hilltop.
About the Hilltop population, those are the bigger boys. And that population would include those that the court would designate that child to be there, as well as it houses children that are going to transition to adult institutions.
Ms. Hamilton, could you assist us? How many persons have been convicted for murder who are presently in your institutions?
At Hilltop, I would say probably under 10.
No, Hilltop, convicted or charged?
Convicted.
Convicted.
Right. So the children at Rio Cobre and Hilltop for boys.
All right, no, 1 second. Hilltop, you say about 10 persons are there.
Under 10.
Under 10?
Yes.
I mean, you don't
Yes.
have a figure
Not the
8, 9,
specifics,
but
right.
under 10.
Yes.
Who are there for murder. What would be their age range at Hilltop?
15 to 17 plus, because they leave at 18.
They leave at 18, so 15 to 17 plus, just under 10. That's Hilltop.
Yes.
Okay. What about the other institutions where you have
At
persons?
Rio Cobre, we don't have that kind of offense.
Okay.
But you also find them at Metcalf, because that is the remand center. They are waiting.
They're charged.
Right.
So effectively, you have under 10 persons charged, convicted for murder.
Right.
and they're basically 15 to 17 at Hilltop. Members,
I just want a clarity on one. You mentioned that there was one that the numbers fluctuate on a daily basis.
that is...
That is the Metcalf
Metcalf.
Street
Okay,
Remand
so that's a
Center.
It's a remand
transition.
center.
Right,
Okay.
it's remand.
Okay, okay.
Senator Binns?
Thank you, Chairman. Hilltop is only for boys, correct?
Yes,
And South Camp would be for girls.
girls,
So of the 75 at South Camp, 43 are on remand,
right?
and the other 32 would be there for.
29, yeah. Yeah, 32, that's okay.
Okay, the others would be there for what? And of the remaining population, how many will be there for murder?
For the girls,
For the girls, yes, South Camp.
it's a smaller number. I can think of about 1, 2.
Okay. For murder.
And those would have been recent cases, yes.
Okay, and they would have been convicted or they have been charged?
They would have been convicted.
And is
So
that
at South Camp, you have a remand section and a convicted section, where we call the correctional orders.
Okay, but for murder, you say you have one or
About 2,
two, and those girls would be 15 to 17.
right.
Okay.
Just a follow-up, and
Sure.
not related to the specific issue before us, but I can't help but to ask, given the number of children who are there on remand versus those who are there for an offense, is there a separation?
Yes, there is.
Okay, and the separation is
So we
at all
have 2
times?
sections,
All right.
one for remandees, one for correctional.
And the two do not meet?
They
at
don't
any-
mix for any reason at all.
Member Williams?
Director Hamilton, in relation to Metcalf, you had outlined the offenses earlier for persons who are children who are at Metcalf. Could you just repeat the offenses for me, please?
The whole gamut, from simple
gamut.
larceny to rape to kidnapping to murder, assault, OB harm.
Okay. And that is on remand. Those are children awaiting trial.
Right.
Are you able to say how many at this moment are awaiting trial for murder?
No, I did not do the breakdown, but it is
Okay.
available.
It's available?
Yes, we do a head count.
It would be useful.
Yes.
All right, thank you.
You're welcome.
And just to follow up on that, those persons awaiting charge of murder, they are in the similar age group, 15 to 17.
All the children within DCS are between 12 plus to up to 18. So if they're at Metcalf Street and they would have attained 18 before their case is disposed of, they are transferred to Horizon Adult Remand Center.
Okay. One second. Senator,
Thank you, Chairman.
go ahead.
Just a follow-up on South Camp, can you give us the ages for the
Girls, same 12 plus to
the two?
17
No,
plus.
there's two. You said there are about 2 who have been convicted of murder. Can you record
Yes,
their
I think the
ages?
ages are between 15 and 17.
So the impression I'm getting, sorry, go ahead first, Senator.
You had indicated rear cobra, and you gave us a number. You said 19 were high security, right?
Yes.
But those high security are not related
Mixed with
to.
the medium security.
No, what I'm trying to understand. You refer to the 19 as being high security. What is that? What is the description of high security for an individual?
Okay.
And does it relate to offense that makes them high security?
Yes.
What
The
is it?
offense.
Oh, it's the offense.
Because what happens when a child is given an order, which is a sentence, and comes into the institution, they have a SER, a social inquiry report, and we do an interview at a placement committee meeting. So along with the social inquiry report, the interview of the child and interview with parents, we use all that information to make determination
as to where they are placed.
what level of security risk they are.
All right. But the specific question, are any of them at Rio Cobre on a charge or convicted for murder?
No,
No.
no. And if a child is charged for uncontrollable and given an order, they are not placed at the hilltop side.
Senator Motley.
Yes, thank you, Director. Those who are serving sentences, who are convicted of murder, what sort of range of sentences? What sort of range? Like
Of
how many
sentences
years?
That they
Yes.
got, yeah.
Okay, so majority of the high security, the wards at the high security will fall in the age range 15 and over. So that would be 2 years, a year and a half, sometimes 6 months, sometimes 3 months. It's dependent on what the judges.
No, but I wanted to, what I was trying to find out is how many years would a judge have sentenced them to? Because you say that there is a period when after they reach 18 they go to Horizon. So I wanted to know, for example, is it 5-year sentence? Pardon me? Yes. How many years on average? If you can't,
Seven. At 17 and they get a 7 year, they'll go over.
I think if I might help, Senator Motley, those persons, young juveniles who have been sentenced for murder, what sort of range?
Yes, that's what
What
I'm
sort of
asking.
range? Yes. I mean,
No.
1 year, 20 years, what
I
range
think the
of-
max is 15 I've ever seen. 15 years.
as a sentence?
Right.
And what is the
So
lowest?
at the probably 7 or 5.
So you're looking at a range between
But
5.
they're always going over to adult institution.
No, but when they come to you, the sentence where I think the members are
Yes, I'm
asking,
trying to
what is
find
the
out.
range? Is it between 1 and 5, 5 and 10, 5 and 15?
5 and over.
Yeah, but
But you're not sure. If you're not sure, I don't
No,
want
it's-
you to say.
It depends.
Yes.
When they get, say for example, a child comes on a murder charge, and the child is 17 years old and gets a 7 year, that means they'll only spend 1 in the juvenile facility.
Yes.
So the other 6 is going to be spent
Yes,
in
and
the
I
adult.
understand,
that,
I
yes.
just want to know, when they come there, how many years the judge say that they have to serve before they can be paroled?
in other
It's not stated.
No, we know, you know, that at 18 they move on.
Yes.
But what I think the member is asking, when they come to you at 15 or 16, what is the range that, to the best of your, I know they only spend 2 or 3 years with you, but what is the range of sentences that, to the best of your recollection, they get?
15 years.
Up to 15 years?
Yes.
And you also said that you have a range of responsibility and for their psychosocial well-being. There is some data that we got which says that there is that 3 out of 4 children in prison had a mental disorder and 20% had a serious mental illness. Have you any knowledge of this? And if the answer is yes, do you have any provision which is made for help for those who have a mental disability?
Speak up in the mic a bit, just pull it down a little bit, so they're recording upstairs, so they need to hear it.
Yes, we do have that count because we have a medical unit that works with medical doctors, psychologists, and psychiatrists. We have a schedule that the institutions work with. So within any week, we'll have different psychologists and psychiatrists who are scheduled to be at all the centers at different times. So when they come in, they'll all do their medical, they all do a psychosocial assessment, although we don't have the designated tools to work with, but they do an assessment and those children are diagnosed and some are placed on medication, and so we have that breakdown available.
Needed, we could have carried it, but so I'll definitely get it for you.
So-
I've noted
No, I think
I've noted them all, and I'll
Yes,
ensure that
yes.
you get it. So
no, I think, to be frank with you, the main intervention will come with
Yes.
just getting some
But
some
just-
statistics. I think they were very keen on what can be done for them.
Yeah.
But we're trying to get some basic information.
And I wanted to add that we are better equipped now with the hiring of a psychologist, psychiatrist recently, but there's a psychologist assigned to each institution, and based on the directive from the courts or the medical assessment, they are treated as per the
Right,
outcome of-
so that was my other question,
Yes.
Dr. Thomas. So when they come into the institution,
Yes.
there's already a notation that they have a mental illness?
Often from the courts, we could
Yes.
get that, but also our internal assessments will do with that, because we have to know who we are getting and treat accordingly.
So everybody who comes in goes through that assessment?
Medical, yes.
Thank you.
Senator Gill?
Yes, Chair, I'm going now on the behavioral change. So you would have identified upon your first assessment that there are some that are high risk. Can you give us a feel as to a change in behavior from becoming high risk upon entering, and if there's a change, likely change? That's one. And some may have not assumed the high risk portfolio, but are there situations where, whilst they are there, their behavior would have been determined as becoming now high risk?
Thank you. What we do when they come in, they do an initial admission. We also do a risk assessment, which consists of two aspects: risk of harm to self and others, and risk of reoffending. And this is done on our juvenile case management system, which is an electronic system. So once the information is inputted in the information, it will dictate what the risk level is, high, medium, or low, and what are the interventions that are needed. So a child comes in, say, not necessarily charged with murder, it could be OB, arm, or robbery with aggravation. So during the interview, you realize how heinous the act was and that sort of thing. And sometimes, and it's important that we do the physical face-to-face interview, because you see the body language. They'll tell you to your face that if I had the opportunity, I'll do it again, and that sort of thing. So we know right up front that that's a high-risk person. And so this individual would be placed in a high-risk institution.
But I was more going now, if there's a change in behavior later on, and has that been assessed and determined?
Yes. We do risk assessment every 6 months.
Okay.
So at some point, you'll see them going up and down.
Wonderful. Member Williams, no, sorry. No, hold a second, Dr. Thomas. No, I want to get Dr. Thomas. You wanted to say something.
It's mentioning that they are tracked, so there are case managers assigned, basically social workers who track their progress throughout and advise accordingly.
Okay.
Just for clarity, and so the social work intervention program is continuous throughout the system?
Yes. It's called through care.
Those that, and permit me, Chair, I beg you, those that now move on because of age to another facility, is there a medium of tracking their behavior? So you would have gone through the intervention, you would have had them, you would have pursued their change in behavior, and now they either have to go to another facility because of age, or maybe to reintegrate into society. Is there a program to assess that behavior going forward?
Normally, we're not
I'll put it differently. After they leave you, do you keep in touch with them?
at the adult institution.
Oh, thank you for that,
No,
sir.
No, they don't.
no.
I'm going to come back
So
to...
is there a case file that goes with them
To the adult
to
institution.
the adult facility?
No.
So you mean when they leave you at 18,
Yes.
it's almost as if they're coming off the street to the adult institution? You don't send a case file to the adult correctional so
Their
that
case file is closed at 18.
it's closed.
It's closed.
Oh dear.
Because after 18,
You know, the jurisdiction.
below 18, they
You're-
don't
they're
have a
with you.
criminal record.
And they're with you. I mean, they're with you up to age 18.
Yes.
What I think, Senator Gale is contemplating how that person who has been with you, what continues. I mean,
Yeah,
it's
so-
almost as if you're starting afresh.
What we
Yeah. So where I was going, Chair, if
yes.
You want the same point or?
no, it's the same point.
Yeah, no, go ahead.
Where I
Just
was
that.
going is that so the intervention of a rehabilitation should be a continuous program because you're dealing with the same individual. The only difference is that the age would have changed and the facility would have
Right.
changed.
You see, let's put it bluntly, Dr. Thomas. I think members have been contemplating when a child, a juvenile, is sentenced, what is the likelihood of a period during which that child hopefully can be monitored and hopefully rehabilitated before they leave the institution? So I think Senator Golden is the one who have been was trying to get this check. So members have now come to the point where they want to know. The court and parliament have to sentence children, juveniles, 15 to 17.
Yeah.
A primary consideration that presenters have put to us is that the focus should really be more on rehabilitation, lifting them out so that they can go back into the society. And eventually, you will be asked the question, but I might as well ask it now. What period do you think would be needed for that child, 15, 16, moving in, could be kept by the institution so that they can become reasonable citizens if and when they're released, okay? I think Member Williams have been trying to... Donovan, I know you have been waiting. You want to come now?
Oh, no, you can wrap. You can wrap up.
Minister Williams.
No,
All right,
I
Minister
coulda-
Williams, then Senator Golden.
No, I thought you were.
No.
Oh, you
go
wanted
ahead.
no. Yeah, I just wanted to say, just to back up a little, that my question in relation to the number of persons on remand at Metcalf for the offense of murder, I just wanted to put it in context for Director Hamilton and Dr. Thomas. The reason we are here, we're looking at mandatory minimum sentences, and we're looking at it also in the context of children. And so we're looking at murder. And so the reason I asked that question earlier was to ascertain, looking at the frequency of, I know charge is not conviction, but at least we wanted to ascertain how many, persons, and tracking the statistics, how many persons on a yearly basis or a 6-month basis, how many children are we taking in at Metcalf who are charged for murder. So we could have a look at where we are. Are we seeing an increase in the number of persons on remand, number of children on remand for murder over the past 3 years?
Yes.
Is it getting worse?
Yes.
Yeah, so that we can know where we're at in relation to informing our position on this committee in relation to mandatory minimum sentences for children. And so that is where my question is. So I'm asking if we could get that information, a kind of comparative analysis over the years, emailed to us, because I gather from day one that was Senator Golding's concern. Where are we? How many of our children are committing murder? Is this a knee-jerk reaction, or do we have tangible, real evidence to show that, look here, we need to do something about this? And so that is where we're at, where we're looking for this kind of tracking in relation to murder.
Before you answer, Dr. Thomas, I think Senator Gold.
I'm going to yield to Dr. Thomas's answer, and then I'll ask my question if necessary.
I may have missed it.
No, just given the commitment to get that information. As
Yeah.
I said, if I'd known that we needed that, I'd
Okay,
have
okay.
because we have a unit that tracks these things.
I don't know if it's here, and I may have missed a meeting,
No,
or
it's not
I
that.
may have
We have
missed a
that.
committee
No, it's
meeting, so I don't know if it is here, and I may have missed it.
We have some information in it.
Okay, very well, very well.
So we'll get the additional
Yeah.
questions,
All right.
the numbers.
Okay,
All right,
guys.
Senator, sorry, Minister Williams.
Yeah, just a quick question. What is the youngest age of a child who has committed murder that you've seen?
I don't have that information, but we can get it to you.
Okay.
Okay, you don't-
Senator Golden.
Don't
Thank you.
recall, you don't.
Thank you,
don't-
Mr.
don't-
Chairman.
don't-
And I just-
One second. Yes, sir. You can, I think Minister Williams wants to know if you have any recollection of the youngest.
No,
Yeah.
no. That I would have known, say 14.
You can think of a
15.
14-year-old who was convicted for murder.
Yes, I think,
Okay.
this small child.
Okay, I mean, you can check on.
Yeah, we can check and verify.
Thank you.
Where?
Was
Oh,
the,
that one? She's with us. I think she's 17. She's
She's,
17 now.
all right, Senator Golden.
Thank you, Mr. Chairman. And Mr. Chairman, before I ask my question, I just want to say thank you very much to Dr. Thomas and Director Hamilton. I know you got very short notice to be here, and I appreciate, certainly as a member of this committee, you appearing and answering our questions. And thank you, Chair, for allowing me a delayed attendance this afternoon. I think my colleagues have taken the inquiry into the direction I would have gone in. So we know now that at the 18-year cutoff, file is closed. The juvenile, who then is an adult, is transferred to an adult correctional institution. And there's not really any communication between the two in terms of what has transpired in development and progress and treatment and rehabilitative interventions for that juvenile during the juvenile correctional period. So my question is then, and I have reviewed the document that you sent in relation to the types of rehabilitative interventions that are made. Can you tell us a little bit about the rehabilitative interventions in the adult correctional facility? Can you give us a little bit about that? I mean, essentially, and let me just give a little bit of the background. We're looking at mandatory minimum penalties, as Member Williams indicated, of 20 years for children. But really, they're only spending what looks like about 2 to 3 years of that in the juvenile correctional system.
Yeah.
After that, they're in the adult system. So it really ought to be the interventions in the adult system that we interrogate, particularly in a situation where there's no transfer of information. That seems to me to be a gap, as I think we are all musing about, that needs to be corrected.
Yes.
So I'd like to hear a little bit about the adult correctional interventions. That's my first question. And the second one I'm going to ask at the same time. Can you indicate, well, let me allow you to answer the first question, and I'll ask the second one.
You want to go ahead, Dr. Thomas? One second, you want to intervene?
I do want to make an intervention, but I prefer to have Senator Golden Campbell finish her line of questioning first.
Okay, all right.
So I will just
All right.
turn off.
Turn off your mic, and then you go ahead, Dr. Thomas.
All right, no problem. But before, I wanted to come back to the issue that was raised. It seems as if you're in our internal meetings, because that is definitely a gap that seems to me to be very obvious. But I think you muttered something that is along the line. We may have to get the instruction, because there are some old rules that guide how we operate that we may have to change, and there's no question. The policy that we got greenlit recently, Minister, in the subcommittee that chaired by Minister Chang, is going to address a lot of these concerns, Jamaica Correctional Policy. especially in terms of what do we do after, not just after going into the adult facility, but after going into the communities. What type of support for housing, for reintegrating your families, for getting a job, et cetera, et cetera, et cetera. So all of that, right now we don't have the resources nor the capacity in any way, shape, or form to handle that. But the new policy will come with the staffing and the resources to do so. So that is definitely some already being thought of. And hopefully when it gets to that stage, we'll be celebrating together. In terms of the rehabilitation, the adult facilities, the science is pretty simple and pretty clear. We chip away at the criminogenic factors most associated with crime, and the science tells us that once you are educated, you are less likely to commit a crime. Once you have a skill, able to get a job, get some sort of employment, you're less attracted to a gang. Once you have therapy, you're a lot less likely to reoffend. So it focuses along that line. So persons in our care at the adult side benefit from academic programs, vocational programs, life skill programs, for example, de-escalating a conflict, how to build your self-esteem, how to manage your finances, take care of your family. That's all we mean by life skills training. Sports, as you can imagine, and of course, therapy. They also get counseling from our chaplains. So it's a whole mix. And we have the listing that we could share. It's a little more than the juvenile population, but literacy and numeracy, English, reading, mathematics, CSEC, you name it. So right now, in our care, the persons learn to read and write. There are persons in the adult facilities pursuing a CSEC subject, and there's also some persons pursuing tertiary education in our facilities. So through UCC, they're pursuing an associate's degree in business administration, and through the UWI, you can learn events management.
Could I just, do you have the concept of a halfway house?
Yes.
Where the persons, although they're in the institution, you would allow them to say go to a tertiary institution or evening classes and return to
Not
the
necessarily
institution.
classes, but they can work at the hostel. That's what we call it, a hostel.
The halfway,
so you
the
spend
hostel.
a period of time before being fully released to,
So if a person is incarcerated and is not a high risk,
Definitely.
and you trust them, they can go to classes elsewhere.
Yes.
Have that experience been a good experience for you?
Well, not classes, but work. So
Work.
they have worked on the outside. We haven't had anybody, do you recall, anybody in the hostel going to classes? Not from our liquor. It's more work. So to get the experience, you have a phone, you go to a job, you come back to the hostel for a period of time before being released. You benefit from the psychosocial support and different programs, and then you're a little bit closer to reintegration because of the process.
But that doesn't, those who are convicted of the offense of murder don't have access to that kind of intervention, do they?
All of our policies are presently under review, so we're actively looking into that. So, for example, it's not only just what you are convicted for, but at the time when you are close to the end of your sentence, and your risk level, because of the continuous assessment, shows that you are no low risk, then you may be able to benefit from that.
I see.
Particular service.
I see. Director Hamilton, you said earlier one of the reasons the case file is closed is because at that point they transition to adulthood and the juveniles don't have a criminal record. So for a juvenile who has been convicted to serve a 7-year sentence for argument's sake at age 15, they are with you until they're 18, and then what happens after that? They begin their criminal record after 3 years of incarceration in the juvenile system?
Yes, they do, and that is because, one, when they come to us with a correctional order, they come with it up until they're 18, but they also have a writ that will admit them into the facility because the correctional order cannot admit them into the facility.
Okay,
so that's where the fingerprinting and everything else will take place.
At the age of 18?
Right.
And at that point, they only have, in my example, 4 more years.
Yes.
So their criminal record will show that they were in the adult system for 4 years?
4 years.
I see. Very well. Thank you.
I'm looking at the vocational training. Oh, I'm sorry.
No, go ahead.
Chairman, protect me now, please. I mean,
I don't say the green light, you see. They don't like the green light.
Right.
You see.
I want to go back to the vocational training. And when I look at them, it appears they are time bound. There are some that provide certification with heart. But let's assume that someone would be there between age 15 and age 18. Are the programs designed for a movement in levels? So in other words, you come in at entry level. Is there an opportunity to go to a level 2, a level 3 within the period? Because it's not expressed like that here. And I don't want to assume that the only opportunity is to a first of all engagement, but there's continuous learning ability.
Thank you, member. It is important for us to understand where we are, where the base is. Currently, we have over 83% of the population of 204 that are illiterate. So we are talking about children at 17 who is reading at grade 3 and 4. So within the juvenile facilities, we do not place them in groups according to age, but according to academic levels.
Oh.
That Chairman, Minister, gives us an opportunity to really understand the layer of the land that we are dealing with.
Yes.
Yeah?
And not only that, but just add this into the mix. I mean, we have children, say 50% of the children at South Camp between Correctional Order and Remand Center has been expelled or suspended from school, has not been in a school environment for a year or 2 or 3 when they get to us. So what we do with the programs is that what we try, these programs are not structured to last for the 2 years that they are there. They are 6-week courses, they are 15 or 12-week courses, and some are those that are continuous. But our challenge is to get them numerate and literate.
In the first instance.
In the first instance.
In the first instance.
Do we?
You might want to go on.
All right, finished? Senator Binns.
Thank you, Chairman. Senator
Yes.
Gale asked one of the questions I have.
No, same point? Would you
I
yield?
would certainly yield.
Go ahead.
I was asking because I've been told that there are teachers in the correctional
Yes, we have
facilities for
teachers.
children. It's not as if they're put there and there are no teachers.
They are teachers.
Okay.
Because we do CSEC as well.
You're right. But the way you were describing it, it sounds as if they do not really get any formal education when they're there.
I was just explaining the levels at which they are because they would have been assessed academically. And so we place them in the different groups, and at the different levels we have the remedial, the intermediate, and the advanced. And advanced is not like what you have in the 11th grade at school. We're talking about children who are coming from grade 8 and 9 with the capacity to learn and are willing to learn. So those are the ones that we send up for CSEC. And had they been in the regular school system, they would not have had the opportunity.
The children advocate would like to go ahead.
Thank you, Mr. Chair. I just had a clarifying question in relation to the teachers who are in the system, the correctional system. Are these teachers as trained by the Ministry of Education, or are these members of staff within the correctional system that have been sensitized to deliver instruction? So is it, for example, a correctional officer who is delivering computer classes? Or are these teachers from our teachers' colleges and so on who have been trained at a particular level, and also the numbers of the teachers in the facilities? Thank you.
Yes, Senator Binns, you want to answer first?
Yes, Chair. The teachers that we have are civilian teachers, and they're all trained by the Ministry of Education.
Okay. Senator Binns.
Thank you, Chairman. Just two questions for Director and then one for Director Hamilton and then another for Doc. You mentioned earlier that we have one psychiatrist. Is it psychiatrist said in each of these four?
Assigned, yes.
One. And so you have one psychiatrist to 83 wards at Metcalf, is that correct?
No.
No, I'm just trying to understand. You have one psychiatrist
I raise
assigned.
that. So you would have one assigned, but as needed. So there's a team available, and then we have psychologists and psychiatrists that we pay sessional based on the needs of the individual. So it really goes back to the needs.
So in terms of permanent, do you have a staff, or do you have a psychiatrist employed?
Yes.
To Metcalf, for example?
No.
You don't?
We're not that privileged
No
yet.
residential.
You don't have one employed to Metcalf?
Just part of the,
so it's
the
like
medical
a
unit.
roving.
Yes.
It's roving. In terms of social workers, do you have social workers employed to each of these juvenile centers?
Yes.
Yes, you do. And what is the ratio per child? Is it a 1 to 8, 1 to 20, 1 to 25? Or maybe you could tell me how many have employed at Metcalf Street.
That would be easier.
So at Metcalf, we should have 4. Currently, we
four.
have 2.
Okay. So you have 2 social workers presently employed for 83 wards. And I'm asking you this because, as my colleagues have said, we're looking beyond just the minimum, but also the psychosocial support for the children. Doc, to you now, if you can help me with the adult side of things, do we have a permanent employed psychologist or psychiatrist?
No, it's the same situation.
It's the same situation.
Medical unit, and they will disperse as needed.
Mike.
Are you able to tell me? Are you able to tell me how many persons that would have transitioned from the juvenile center to the adult center under the age of 21? Are you able to say at this point?
No, I'll get to that. I can get to that information, but not right now.
Okay. That would be important.
All right.
Thank you.
Are there any other questions from members? Dr. Thomas, abroad, a few points to note. We have before us to see.
Chairman, could I interrupt you? You asked about any other questions.
Yes.
Could I just ask a final question?
Sure.
About, do we have any information, Dr. Thomas, on the rates of recidivism? It's always a difficult word for me to pronounce. Of the juveniles who are in those facilities. In other words, and I think Chairman had sort of asked it earlier, but if they stay with you until they're 18, and for those who are discharged before they're 18, what information do you have as to their committing crimes again? And in particular, those who leave your facility and transition to the adult correctional institutions, when they have completed their sentences, are we tracking their commission of crimes after that?
The answer is no, member. And it is a little challenging because when those children who would have left the juvenile institution would have reoffended and go to adult institution, they would not indicate that they would have been in a juvenile institution before.
Okay, you see, Dr. Thomas.
Yes, for more than one
Dr.
reason.
Thomas and Mr. Hamilton. We have a major concern that most of the presenters who came here feel that when we send to the courts how we sentence juveniles, especially 15 to 17, that the presenters, UNICEF, Jamaicans Are Just, everybody, that the focus of the sentence should be rehabilitation, because these are young people who need to be educated, to be transformed into good citizens. What is the likelihood, Dr. Thomas, that if, say, a 15, 16, 17-year-old was sentenced by the court and they're convicted for murder, of that person being rehabilitated, not only starting with the juvenile institution, but in your adult institution, and what period of time you think would be needed for that person to really be, to be kept so that you feel that they need to be there over that period of time before they can even be considered to be released back into the society. Because bear in mind, these are persons who have committed murder. But at the end of the day, they're persons who feel the focus must be on rehabilitation and treating them as if it's a health situation rather than a security situation. What's your view, Dr. Thomas?
Well, one, I'll put a little more thought to that before
Come
giving...
to the mic, come to...
I'll put a little more thought to that before giving a definite recommendation. What we have found, I think, needs to be clear. A lot of persons aren't aware that rehabilitation is mandatory within the juvenile facilities. So you have to engage in rehabilitation. So once you do your risk assessments and we realize that you need to, your reading levels are low, which is, as you just heard, the vast majority, or that you need therapy, you need counseling, whatever you need, you have to participate in those programs. As it exists now, it is not mandatory for the adults. And that is where a major gap that the policy is seeking to fix. So rehabilitation, according to the new policy, will propose that all adults must participate in rehabilitation, and that will come from the courts and just mandated for everybody who is in our walls. And in that regard, now again, I know I can preempt Ms. Hamilton here to say, it is again going to come down to the person and the assessment. Because there can be somebody inside, and correct me if I'm wrong here, for murder, but still not high risk in a short period of time. Because they came home early, is a running joke, and that is the situation as opposed to somebody who is a lifelong young member who has several crimes leading up to murder, and the risk assessment says if they go back out, they'll be actively engaged in gang warfare. That's a different person altogether, so the treatment will be very different.
So Dr. Thomas, you're looking at a small number, could be less than 10.
Yes.
Is there any possibility of you saying, or you administratively,
yes,
those persons coming from the juvenile institution, that you treat them separately in your adult institution for continuing rehabilitation, which would have started when they were juvenile?
So
is that possible administratively?
So I think what is missed is that, well, the short answer is yes. And as I said, the internal discussions have already started. There are some very old rules, and it's the letter of the law versus the spirit of the law. That says, okay, we don't want to track you because you're a child. So they seal everything. So you're not even tracked in terms of recidivism. You're not tracked in terms of your treatment. Everything is sealed, and a new file is opened.
No, I know, Dr. Thomas. And I think the problem that members are having is the lack of data.
Yes.
But you're now working with Synergy.
Yes.
And I hope that those data will be readily available. Because Synergy, we are going to be working with Synergy in the courts too, so that more data could be readily on your computer.
No, but we do have a computerized system, so we have the information. The question is, are we going to change the rules? Exactly, it's a rule and the policies to say, do we track continually? And there are ways of doing it, of course, in internal discussions. We remove the names, you have the numbers, whatever the case is, because the information is critical as we plan, which I think is what you're getting at.
But I'm sure you're participating in the new Correctional Act.
Yes.
So is that a part of the program?
Yes, definitely.
Right. Senator Bins, you?
I will yield to you since you picked the
Thank you, Chairman. I wonder, Ms. Hamilton, Director Hamilton, I wonder whether, and I know each case has to be determined on its own facts, but in your experience, if you find any commonality among the children who have committed murder, do you find that they're from single parent, or is it illiteracy? Is it because they have some kind of mental challenge? I don't know. Is there any commonalities that you find running through the children who are specifically charged with murder and or other serious crimes? So that's the first question. And for Dr. Thomas, when you talk about rehabilitation, I just want to clarify whether there is the engagement of the family, the extended family, the nuclear family, perhaps community, in the rehabilitation process?
Thank you, Member. There are similarities, and it goes across both the girls and the boys. A single parent household, maybe one parent died. You have the grievance aspect of it where they lost a member of the family, and sometimes they're about vengeance. Then there is the lack of parental guidance and also the associates within the communities.
Chairman, I really don't mean to detain the officers. Oh. Oh. Okay.
You want it?
Yes. We always want to expand and improve. The staff issues will prevent a lot of what would be ideal, as you can imagine, security concern, numbers, all the above. But there are family days where the families get to interact. Every single child has the opportunity to speak to their family members each week, whether it's phone call or is it Zoom? Okay.
They're asking specifically if within the rehabilitation process that you have, the program, if there is any provision for involvement of family. So that is a specific question I'm asking.
Not as much, not as much. There is some interaction, but not clearly. So it would be part of the training in the life skills manual in terms of families and all of that, but in terms of the interaction with the outside, which is what I'm trying to group in. That is not for lack of now, because we know it's important. I know that's what I get. It's very important. And we have ministerial directive to bolster that effort. But we have to put those resources in place, ensure the necessary security protocols are followed, etc.
Actually, Dr. Thomas, I think the Ministry of Justice will be in touch with you for restorative justice, so that there's that interaction, especially with families, especially where there are incidents. We have had a few good cases where you know, I think you know the case of the sister who killed her mother, and the sisters did not even want to see her, and we were able to get them together. And now the sisters are visiting the one in custody. And
cases, yes.
Right, so we know of many cases, and the Restorative Justice Unit would like to develop that to assist in the rehabilitation process.
Very much welcome.
Yes, Chair. Dr. Thomas, already in my mind, I strongly believe about this tracking to the adult stage. And most of the groups that have met with us have expressed the need for serious rehabilitation. And I view rehabilitation not just as an intervention or a reservoir that you conducted the rehabilitation, but more, what I want to ask, is there a performance threshold that has been set by the facilities to ensure that, listen, we need to meet this mark? Is there an improvement that we need to meet over a period of time, as opposed to it just being an engagement of going through a system?
Oh, yes, the courses set the standard if we're referring to just the courses by themselves. But again, to follow Ms. Hamilton, to set a sort of context, right? And I think you also asked about the progression over time. We did an assessment through heart of our facilities, and the vast majority of spaces that we do rehab is not suitable for a heart trainer to come in. Again, we don't have purpose-built facilities. So as we said, it's really turn your hand and make fashion, if you understand the language, right? So if the course, for example, is barbering, and heart for level 1, you have to learn how to condition, shampoo, color, etc. What we can do is really just line and shave and the basics, but you can get an income from that. And then on the outside, you're free to go ahead and join and learn and go up the ladder. But we can just offer what is available within the institutions and the spaces, which are usually makeshift, that we have. Once we have the new facility that we hear is definitely coming, we will definitely build out to hard standards that we can go level 1, level 2, level 3, and I'm sure the universities also like lecture theaters and the ability to come in and teach a larger group of people. So we are ready to go.
Right. I'm Dr. Thomas and Ms. Hamilton. We would really like to thank you. I think the information, even though not what we wanted to hear, but is revealing. And what we've heard, which is very important. Very important. So we want to thank both of you for the presentation. I know you were jumped on late in the evening, but it was very important for us to have that information. And I want to thank you, and we can excuse you if. Colleagues, we have some very simple questions, but are questions which could be complex depending on what answers we rely on. There are 3 bills, and they're very short bills. As we are aware, most of the input came from the presenters concentrated a lot on the children, and that is the Child Care and Protection Act. My understanding in relation to the Child Care and Protection Act, since we met yesterday, and we can get some information from the technical team, is that the bill does not apply to children 12 to 14. In other words, the children 12 to 14 remain under the Child Care and Protection Act. So they would be sentenced as the court sees fit. That's 12 to 14. But the bill applies primarily to 15 to 17. CPC and SG, is that my understanding? Just turn on your mic there.
Chair, it's more that the provision that we're dealing with deals with the narrow category of offenses to which the sentence of death applies. So it's not all categories of offenses generally. And in addition to that, there is a nuanced scheme in the Child Care and Protection Act determining how the child is dealt with depending on the age.
12 to 14?
12 to 14.
So under the Child Care Protection Act, the Child Care and Protection Act determines how children 12 to 14 are dealt with, even if they commit murder?
Yes.
So really and truly, that was one of the proposals that was put to us, that we do not have a minimum mandatory anyway for children 12 to 14. So we don't need to deal with children 12 to 14 since it is covered by the Child Care and Protection Act. CPC, just remind of the section.
It's section 78.5, which deals with the child under the age of 14 years, where the child is convicted of an offense specified in the 4th schedule, and one of those offenses specified is murder. And the provision that we're amending has been made specially subject to subsection 5.
Right. So when we look at children, therefore, juveniles, under this present bill, we're looking at juveniles 15, 16, 17, okay? The DPP proposed that we should separate those who commit capital murder from those who commit non-capital murder, okay? So we now need to ask, I spoke to CPC, and she says that where the bill speaks about where the offense is murder, it should be murder punishable. There should be
in keeping with what is in subsection 1, which is what this amendment relates to, subsection 1 only deals with offenses to which sentence of death may be applied, and it converts that to imprisonment for life. And now we're specifying the minimum sentences that could be imposed.
So in subsection 2.123A, CPC suggesting we add the terms where the offense is murder, punishable.
Well, I have a little refinement. First of all, I'm suggesting that where we refer to child, it should be person, because subsection 1 talks about a person, because it also deals with persons who might be before the court, who are not children, but at the time they committed the offense, they were a child. So I would make that change to change child to person where it appears in the new subsection 3. And then in 3A, where it says where the offense is murder, we would add the words for which a sentence of death could have, but for subsection 1, been imposed. Just to make it clear that the category we're dealing with is murder that attracts
Right. So
the
this
death
would be the one area where if the child, 15, 16, 17, is convicted for capital murder, okay? So subsection 2, 3A here, where we say where the offense is murder, specified period of not less than 20 years, it would only apply to capital murder. Correct, CPC? Right. So the change would be apart from child, we put person, we say where the offense is murder for which a sentence of death is applicable. No, just repeat it. Just get it correct.
For which a sentence of death could have, but for subsection 1, been imposed.
All right, so we'll get that to the secretary. Everybody understand that? So subsection 3A really deals with capital murder. The question that members should now ask, should now contemplate, is the period. And then B now deals with, if I might put it differently, non-capital murder. And the
offenses that attract the penalty of death. So none of this deals with non-capital murder. That, well, in the case of a child, for example, under the age of 14 years, would fall under subsection 5.
No, remember, we're not dealing with that.
Right, but I'm saying that this provision here, as it stands, does not apply at all to non-capital murder, since it only affects the offenses referred to in subsection 78.1, which are offenses that attract the sentence of death.
So, no, you need to explain first. So you're saying that this particular bill deals only with capital murder? Are we clear? So for non-capital murder, go ahead, you want to come and help us now? So go ahead.
No. I wanted to find out if there was an expansion to B.
That's it. 1 second. SG, give us the benefit of your learning now.
That consultation is important.
Exactly. Yeah, CPC.
No, I wanted to find out if there was an expansion to B, to 3B.
No, there's no expansion because in the chapeau, it still refers you back to subsection 1, which deals with the offenses.
So members.
For which sentence of death could have been pronounced.
Right, so members, let's get the first one clear. For capital murder, it applies. The question we must now decide on, what is the minimum mandatory sentence that must be served before they can be released, okay? At the moment, where the proposal of the bill is 20 years. So we need to make a decision whether we accept the 20 years or we reduce it, okay? The next question, CPC. Where is non-capital murder dealt with?
Chair, I was looking at the provisions, but I'm only seeing a reference here where the child is under the age of 14 years.
No, we're dealing back at the 15, 16, 17.
Right, but for the 15, 16, 17, again, there's not a specific provision here, so it would take you back to the options that are provided in section 76.1, methods of dealing with child offenders, which would include sending the child to a juvenile correctional center. So I think the court would then determine the period.
You see, the concern is for that would be for non-capital. So the effect of what we're saying, if I understand your CPC, this bill would not deal with non-capital murders sentence for non-capital, for offenders who are convicted for non-capital. Huh? I must admit, I thought, because the view, is that for any murder, there should be some minimum mandatory sentence.
I think what may have happened here was that during the deliberations, we made a distinction between capital murder and non-capital murder.
That is correct.
And if the proposal was to treat with capital murder, then that's what we are dealing with.
Right.
Now, we may have to consider how we treat with the non-capital murder. If there's any other submission or recommendation.
Well, this is for the committee to move forward. You see, we can, what will be necessary for the committee to consider? Because CPC would have to help us. If we think that for non-capital murder, the person should serve a minimum period, whatever the period is, then CPC would mean we have to add something to this bill.
Not only sentence of death, but murder where the sentences could be other than a sentence of death.
Mr. Chairman. Mr. Chairman.
Yes.
I'm sorry, I'm extremely confused because it was my understanding that the entire purpose of this bill was to deal with the capital murder, that it was not contemplated by the policy to institute a mandatory minimum in respect of non-capital murder, that would be left for the courts to determine as the circumstances presented themselves. That was my understanding on entrance into this committee.
We don't have a problem, Senator Golden. If you
Mr.
want to
Chairman,
leave it, we can leave it like that.
No, Mr. Chairman, but it's not something that I want us to decide on a whim and a fancy. What is our policy? What is the intent here? It's not something that this committee really even, it's within the purview for the committee to decide one or the other. We have a bill presented by the ministry that we are debating in terms of the provisions of that bill, and that bill addresses capital murder.
Okay.
Capital murder.
Right. So you're saying...
So I don't think we should embark on an excursion to institute mandatory minimum penalties on non-capital murder. That wasn't what was presented to the committee.
You would leave that to the court, the court's discretion.
That is my understanding of the ministry's policy on it, yes.
No, it was...
That's not the policy?
No, no. I think there's no doubt that the idea was that this is coming from Minister Williams. I think Minister Williams, coming from the Ministry of Education, the idea was a minimum mandatory for murder, capital.
Well, let us be clear about what we mean, because sometimes when we band about these terms, the citizens that are listening to us don't understand. Capital murder, we're talking about the most serious type of murder. The murder that is deliberate, that is premeditated, that the person is planning. Non-capital murder, we're talking about murder that happens...
Less egregious.
Yeah, I'm really saying this for the benefit of the public, Minister. I know you well know what it is. But we're talking about the murders that happen by virtue of a fight that ends in a murder, by virtue of somebody in a moment of emotion.
Go ahead, Senator Sinclair.
Senator Sinclair, no, I'm happy to yield to you because I'm not a criminal lawyer.
Yeah, but it's just that, and I've heard it when we were taking the presentations, because even the comments being made by my colleague relates to, and giving specific examples, don't seem as if those instances would be murder.
What would they be?
Let us... By the way,
And if you go to manslaughter, then you get into a different
but
realm.
So can you explain the concept of non-capital murder then?
No, let us non-capital murder
You have to look
is
to the offense against.
basically the less egregious type of murder.
but what does that mean?
Where the person might definitely intend to kill, but it is maybe in a moment of rage, right? No, but it's a deliberate intention.
Charlie,
It's
just
a matter
explain.
for the DPP. To be frank with you, colleagues, if you look at the DPP submission, DPP's submission was basically for non-capital murder, there should be no minimum mandatory. That the DPP's presentation from the DPP was just that the minimum mandatory should be for capital murder. That's right.
No, I was saying also that in addition to the observation which you made, she also pointed out an anomaly with the sentence of 25 years as against this proposed minimum mandatory of 20 years for capital.
Right.
She did say that the committee needed to take a look at that.
No, there's no doubt, definitely. So, Minister Williams, this is your bill. We need to look. Yes, we need to look, and it may well be, we need to look to see if we agree with the understanding of Senator Shireen Golden Campbell, that the mandatory minimum should only apply to capital murder, which, to be frank with you, was the submission of the... Yes,
Minister, please, I beg you, don't misstate what I've said. I don't have any position.
No. But
I am
said
simply
your
saying my understanding was this. Now, if there's a clarification of what the policy is, I would be grateful.
Yeah.
Because my understanding of what it was that we're only dealing with capital murder. So I would appreciate the clarification myself.
For the juveniles. Go ahead. Yeah, go ahead.
The bill that we got suggests murder, that we're dealing with...
Capital murder.
No.
Murder.
It says murder. During...
The memorandum of objects.
Yes.
Says murder, but
right.
not the section, which is what Ms. Grant is saying. Can I interrupt you?
Sure.
Will you permit me? So the memorandum of objects and reasons speaks to murder. But as Ms. Grant has pointed out, the section which we are amending specifically speaks to capital murder. So the memorandum is not compatible with the section which we are amending. That's what she's saying. Am I? Yeah.
So Ms. Grant, CPC, what we're saying is that this bill contemplates just capital murder.
Stands, yes, Chair.
Yes. Minister Williams, it's a matter that you have to will clarify. I must tell you that the general presentation and sentiment of the contributors was that, including the DPP, was that non-capital murder should not be a part of it. Leave it to the judge. So if it is agreed that this bill, as is the understanding, only deal with capital murder, we can leave it at that. So the question then we must ask, which we need to answer, is the minimum period for capital murder of 20 years agreed? Or do we want to change that, colleagues? Bear in mind, this is capital murder. I get the views of everybody. Huh? Remember, Mr. Donovan Williams, what's your view? Leave it as it is, less, more. What's your position? Turn on your.
You see, the Section 78 of the CC, the Child Care and Protection Act, confers the discretion on a judge to sentence a child under 14 years.
No, leave that out.
No, I mention it for a particular reason. Can sentence a child up to 25 years. Now, if it is that a tribunal can do that, sentence a child up to 25 years. So there is a contemplation that there may be certain egregious offenses for which a child, now, albeit 14 and under, can serve a sentence of 25 years. Then how then?
No, remember, this is not the sentence. This is the period of mandatory minimum. The sentence might well be life imprisonment.
No, I know.
Yes.
So this is where I'm going now. So if you can attract up to 25 years, if you cannot go beyond 25 for the child under 14 years, then how is it now that for capital murder, you're going to say a child between 15 and 17? I think, perhaps we should up the years. That's my view. Perhaps we... Pardon me? No, perhaps I'm saying...
Bear in mind, though,
yes.
Member Williams, if the judge sentenced a child up to 14, in the most egregious situation, which is the maximum, 25 years, the judge may well say, but that child must serve at least 10 years.
Yes, before being eligible for parole.
So bear that in mind. So we're looking at where, in this case, the judge could sentence the person for capital murder to life imprisonment. Yeah. So the real question is, what is the minimum time that child should serve before they are...
No, I am clear on that, But I'm saying, even in your hypothetical situation, a judge could also say that, notwithstanding the 25 years maximum, that person could be eligible for parole after 20 years, depending on that case. So I'm saying, if we have that span for persons under 14 years, because there's nothing to prevent a judge from saying, all right, the maximum is 25 years, you're not eligible for parole until after 20 years. That in essence would act as a mandatory minimum. So we have now raised the level of offense to capital. So we just heard from our director. We just heard from the director that the average sentence for murder that she has seen, and I stand corrected, is 15 years.
No, the maximum.
Oh, well, the maximum, yes, the maximum average is 15 years for, children who are within her jurisdiction serving sentences, 15 years. And I would think that that is for, non-capital, most of the cases, non-capital murder. So that's something for us to deliberate on, additional 5 years, minimum mandatory.
You wanted 15 or, what are you saying, 15, 20, 25? What is your position?
Well, I think 20,
You'll leave it at 20. The bill has 20. What's your position?
Yeah, I think 20 would work.
Senator Binns,
it requires some more thought.
All right. We'll come back to you.
You have both of us on red. Which one would you?
Well, Senator Binns, then you, Senator Martin.
Chairman, I'm so sorry, but I can't answer your question because I am still a little boggled, and perhaps because I wasn't following the conversation, because there's a point that made that had me confused. I was trying to find the bills, the acts, and look at them. Because I know CPC made an intervention that Senator Scott Motley repeated. My understanding of what was said was that the bill speaks to murder. Is that correct? What?
Which the penalty of death can be imposed.
Right. But I'm looking at the Child Care and Protection Act. and you can correct me if I'm wrong, but the Child Care and Protection Act, Section 78, speaks to life imprisonment where the death penalty would have been imposed. So it speaks to life imprisonment. And then it further references the fourth schedule, the offenses under the fourth schedule. When I look at the offenses under the fourth schedule, it speaks specifically at 1 to murder and manslaughter. And then it goes on and it lists other offenses, and then it states certain sections in the Offenses Against the Persons Act. I looked at the Offenses Against the Persons Act, and I did not see any reference to capital murder, so to speak. In fact, what I saw was just murder. So I'm still unsure. I don't know if I overlooked it in the haste, but I'm still unsure as to how the discussion evolved to capital murder, because though in our initial meeting we referenced a lot to capital murder, it seems to me that looking at the act, the reference is specific to murder. So before I can give an opinion, I would love some clarification on that aspect before we can move on. I don't mean to detain you, sir, but I think I need to be clear in my mind before I can give an opinion.
I won't force an answer out of you. Yes. Yes, Senator Martin.
Yes, I was taking my mind back to our initial discussion and your passionate representation for the victim. And the fact that part of the motivation for this amendment was because of the public outcry and to satisfy, in a way, by my word, the public's anxiety that the sentences for murder were just too low. I looked last night at the Plea Bargaining Act, and in my view, the victim, that legislation which you have shown a distinct preference for, does accord the victim a lot of input. The victim's rights are protected in that piece of legislation. So when that particular legislation is used, it cannot be used unless the victim has an input. I looked also at the conviction of children for murder. And yesterday, when it was actually put in context, it's actually 8 per year over the last few years. What was missing was data as to the nature of the murder. So when we look at 8 overall and we put together capital and non-capital, one can conjecture that the number of those persons convicted of capital murder might be very low. And so I'm saying that in coming to, we are now deciding whether 20 years, 25 years, how many years suitable. And I have to ask myself, is there justification for interfering with the way that the courts have proceeded in these matters? Because if we're going to do something as dramatic as what we are doing, which is to impose a minimum mandatory sentence, then to me, the legislators need to have a basis for so doing. There is not one single submission which we have had which has been in favor of minimum mandatory sentences. Even the one that you referenced yesterday with Jamaicans for Justice coming to this position and doing the range, when I looked back at it last night and looked at their overall submission, it was a submission which did not favor minimum mandatory. So when you're in listening to the public outcry, when you distill the numbers, Minister, there is no persuasive argument for a minimum mandatory. And indeed, if you see the persons who made submissions as representative of the public, which I think you have to, I don't see how you can avoid it. Every single submission, including that of the Director of Public Prosecutions, did not support minimum mandatory sentences.
You mean for children?
For children. Yes,
No,
aren't we talking about children now?
Yes, yes. No, but to be frank, I think the DPP office did support.
The DPP
I think,
looked at
put
it.
That, say 15 years. I think somewhere. I remember.
I think how it was presented was in the context of what they were being asked to do, and so there was there was some kind. A few persons actually said, okay, if we have to go to that route, here's a range. We need a tariff. The DPP herself had pointed out the anomaly which we were setting about to create.
Sorry, go ahead.
But my overall view is that certainly in a matter so serious, having regard, I think, to Ms. Grant's reminder of what it is that we have embarked upon, I wouldn't want to be asked, so what you think, 20 or 25 or 15? I think it is a matter that requires now for us to revisit all of the presentations and our minutes and to give a very sober consideration to what we are doing, especially after I heard from what the department, thank you so very much for asking for them to attend. When I hear their presentation, I have even more questions than I have answers in my mind, because the system does not really facilitate what we are doing. It does not suggest that we are taking the right step in imposing this mandatory minimum. There are too many other considerations which we ought to take into account before we make this decision, and that's my view.
All right, there's no doubt, I'm coming to the others immediately, but we can get some guidance, because you will recall that UNICEF and everyone spoke about no minimum mandatory for children, okay? But my office, Mr. Bailey and Ms. Chantal Bailey, looked at the United Kingdom and the Criminal Justice Act 2003 and their Sentencing Act for children. The minimum years to be served before being eligible for parole is 12 years. It should be noted that the UK is also a signature to the United Nations Convention to the Rights of the Child. So in the UK, I mean, and we do, for one reason or another, we tend to, adopt a lot of things they do. They actually have a minimum mandatory of 12 years. Isn't that right, Mr. Bailey? That's the 15 to 17, right? 15, 16, 17.
But, sir, you put on my mic by mistake, and I'm going to take advantage of it.
Right. No, I didn't do it by mistake.
Because in the UK, they're moving towards utilizing more of the discounted sentences, which we are rejecting because of the situation in the UK. Because the mandatory minimums have led to overcrowding, for example, case backlog. Just 4 days ago, there was a report about them considering more and more that for efficient management of the cases, to persuade persons to plead guilty, to have matters disposed of efficiently, to avoid the backlog in cases, and to have a proper dispensation of justice, they were more going towards discounted sentencing.
Okay.
Perhaps your office could look into that discourse which is presently taking place.
Mr. Bailey, what did you found from the UK?
So, Minister, yes, as you were pointing out, in respect of children, and it's actually not limited to just 14 to 15. It says below the age of 18 and above the age of 12. They are liable to be imprisoned. They would have to serve a period of at least 12 years before parole can be considered. The other thing to note as well is that for the offense of murder, for the offense of murder generally, yes, murder generally. And another thing to note in terms of the prescription of the sentence for UK as well is that there is a mandatory life imprisonment, but there's another terminology for it, but the effect of it is that it's life imprisonment that is applied to the children once convicted.
All right, you're not leaving. You're not going. We need your views, you know. We can. Senator Sinclair, what's your views? Let's have your initial views.
We're having a brief discussion, but in listening to Ms. Grant and her guidance as to what is contained in the bill, because it makes reference to 78.1, where you wouldn't pass the sentence of death. Obviously, that is only in capital murder cases, right? But you asked specifically, Minister, in relation to the minimum period?
Right. Just let me help everyone, by the way, because I didn't mention...
For capital.
Capital. This was paragraph 41 of the DPP's office presentation, okay? It says the issue of mandatory minimum for a child should only arise in capital murder cases. That is murder falling within section 2.1 of the OAP. Therefore, we recommend that the proposed amendment to section 78 of the Child Care and Protection Act be limited to, quote, where the offense is murder falling within section 2.1 of the Offenses Against the Person Act, specify a period of not less than 20 years which that child should serve before becoming eligible for parole, notwithstanding section 3 of the Offenses Against the Person Act. That's paragraph 41. So she was actually supporting the bill, or not she, the office, as stated in the bill.
And I concur with the view of the DPP.
Thanks. Senator Golden Campbell, you pass? Senator Kevin Gale.
Chairman, this is, I think, one of the most important decisions that we're going to make. And where my mind would have been is that accepting the fact that if we're dealing with capital murder, the decision around a mandatory minimum is around capital murder. Now, this does not stop the judge from exercising his or her decision of imposing a sentence of a higher standard. What we are determining is the minimum standard, the minimum threshold. And I am of the view that what is being proposed is sufficient for the purpose of capital murder for a sentencing.
Right. Thank you, Senator Gale. Minister Williams, you want to put? All right. Colleagues, we have to move on from this, but my position is fairly straightforward. I would agree in many ways with what the Office of the DPP proposed, that the minimum mandatory applies to capital murder. And 20 years is not insufficient, if you ask me. It's appropriate. And the reason why I'm saying so, colleagues, we cannot ignore that the families of the victim may well ask, here you have been indicted for capital murder. You plead guilty or you're found guilty for capital murder, which has that possibility of death or life imprisonment. Life imprisonment is likely to be imposed, and the question is, how long should that person serve before they're eligible for parole? Colleagues, we have to be bold and make it firm that anyone, especially youngsters who understand what they're doing, and I believe from your age 15 going up, that you clearly must understand what you're doing and the consequence of what may happen if you're apprehended and you get convicted in a court of law. So quite frankly, I would urge us to agree that the section applies only to capital murder, and we agree with the 20 years, not less than 20 years, because this bill, I'm urging Minister Williams, should send that signal, especially to parents, especially the parents who have children under their charge, to control their young people. Because if they don't, they may well be visiting these children for the next 20 years, you know, in jail. So, you know, we cannot ignore the fact, you know, that if we don't impose a sentence that satisfies the public interest and satisfy the sentiments of the friends and families of the victim, we leave ourselves open that those families, friends of the victim may well feel that the justice system has failed them. We cannot ignore that fact. And I dare say there are far too many instances of revenge and retaliation because victims of whatever type of crime feel that they must take the law into their own hands to exact revenge and retaliation. And that is why, colleagues, I feel that the legislature, the justice system of which we are a part, we have to send that signal that when you're convicted of a crime, you're going to get a sentence that matches the seriousness of the offense. Otherwise, we're going to have a situation where people out there feel can't wait on the justice system. They're going to exact revenge and retaliation, especially for really serious, egregious crime. So, colleagues, I just would urge that we make a decision at the next sitting and we finalize on children. Minister Williams, I would ask you to look and see if we can leave this section to just capital murder, so we send that signal for capital murder, and we leave it to the judge in less egregious cases than non-capital murder. It might be a serious, egregious case, which the judge might in fact sentence that 15-year-old to a high sentence, but say you must serve 10 years or 15 years, as the case may be. So I think it's a balancing we're trying to do, but at the same time, satisfy the public interest as to what the legislature wants to do. So I'm going to leave that, and then when we meet next, we either agree with what is being proposed, and I really, colleagues, would like us to have a consensus to send to Parliament, you know, rather than saying we disagree whether it is 10, 15, 20, as the case may be. Having said that, that's for the children. You know we don't finish our work yet, and I hope you're ready to deal with the other ones now.
No, we're tired after all of that.
Well, can we just finish the matrix then?
Our lunch.
The matrix is about 3 pages, and then we can look at whether we agree with the other. No, by the way, we are going to put it to the committee, the change to the section, when we come next time for a final meeting. You know. Okay? The change that was proposed by the CPC. Yes, yes. All right. And Drafter said, okay, we will. All right, colleagues, I think most of this relate to the sentence. So colleagues, sure.
Before we move on, Ms. Grant, sorry, let me ask you, under the Child Care and Protection Act, 78.3 specifically speaks to situations where the child is under 14? Is 5? Sorry. 78.5.
Sorry, go ahead, repeat.
That's section 78.5 deals with children under the age of 14 years.
The child between 15 and 18. What's the situation?
It goes back to the powers under section 76.1 of dealing with child offenders. And there's no period specified there. But the court can make an order sending the child to a juvenile correctional center.
All right, colleagues, I think what we'll do is leave the remaining issue, or just what is the minimum mandatory for adults, okay? Bear in mind, for capital murder, it's going to be death or life imprisonment. And the question, if it is life imprisonment, what is the minimum? The bill says 50 years. Moving it to 50, do we agree or do we adjust it? For capital murder, okay? For non-capital murder, the bill says a term of imprisonment, life imprisonment, but you must serve 40 years. Do we leave it at 40 years if you get life imprisonment? Or it can be a term of imprisonment, but you must serve 30 years. So the issue, colleagues, please, I beg everybody, have a look at it and let us come to some agreed understanding. If we say life imprisonment for capital murder, but you must serve 50 years, if we agree, or you reduce it 5, 10 years, let's come to some agreement, okay? In other words, we want to be able to propose to Parliament, and here again, life imprisonment, you know what it means, especially where a judge would not impose life imprisonment unless it is really serious. So there should be a high minimum mandatory. And bear in mind, we're talking about both capital and non-capital murder. So I would say, colleagues, I think we have achieved a lot in the discussion and information. We're hoping by the next meeting, the additional information we'll get from the corrections. No, what time we have next Wednesday? No, it might be too close. So, colleagues, the 25th, that's next Wednesday? That was booked. And with respect, it could be our last meeting. So we're just asking for a final decision making next Wednesday at 10 o'clock. We will sign off on the children, but the other ones is just a question of what is the minimum mandatory for each of these, okay? And then we have to deal with Section 42, the Criminal Justice Amendment Act. So we'll just finish up everything next Wednesday. So colleagues, if we agreed, can we have a motion for adjournment? 10. You want us to say 9:30 so we can be here? Sorry? Motion for adjournment. Thank you very much. Colleagues, I want to thank you all and also to thank the technical team, the children's advocate. Thanks for being with us, Mrs. Gordon Harrison. The Attorney General's chambers, well represented, 3 high-profile persons, 2 from the Ministry of Justice, the CPC, and the law reform. Thanks again, everyone. Meeting adjourned till next Wednesday, the 25th, which I hope is our final meeting. What's this? What's this? What is this all about?
say me and know me are two different things. In other words, you can't really know a person just by looking at them, even if you see them often. Unless you spend a lot of time with them, you can't know who they really are. So